Welcome to this introductory video on the Consumer Guarantees Act 1993, otherwise known as the CGA. Through discussing the main aspects of this act, we aim to inform small and medium-sized enterprises of the significance as well as the practical implications of the CGA. The first main aspect of the CGA is who the act applies to. The CGA applies to any business or individual in trade. In trade means that the individual or business regularly sells goods or services, or they buy or obtain goods with the intention of selling them. There are many other characteristics individuals or businesses in trade may have. However, the only thing that matters to be considered in trade is how regularly one sells a product or service. Okay, moving on to the definition of a consumer. According to Section 2 of the Act, a consumer is defined as a person or business that acquires from a supplier goods or services of a kind ordinarily acquired for personal, domestic, or household use or consumption. This means that it doesn't matter what the product is being used for, as long as the product or service is something which is usually acquired for those purposes mentioned above. There are, however, some exceptions to the definition of a consumer. If the individual or business acquires the good or service to resupply them in trade, consume them in the course of production or manufacture, or use them to repair or treat in trade other goods or fixtures on land, the CGA does not cover these products or services. Next, we will talk about what the CGA actually guarantees. For goods, they must firstly be of acceptable quality. This means the good is fit for all purposes for which goods of that type are commonly supplied for. Acceptable in appearance and finish, no minor defects, and be safe and durable. The term acceptable quality depends on the nature of the goods, the price, any statements on any labeling or packaging, and any representations made by any suppliers or manufacturers. The exceptions to this are if the consumer is told about the defects before buying the good, and if the good is used inappropriately or excessively. Another guarantee is that a good must be fit for a particular purpose. This means that if a consumer makes a purpose of buying the good clear, the good must meet that purpose, unless it is clear that the consumer was not relying on the supplier's skill or judgment, or if it was unreasonable to do so. Other guarantees include the fact that goods must also comply with the description and any samples. Repairs and spare parts must be available, and manufacturers must honor their express guarantees. Guarantees for services include the fact that the service must be performed with reasonable care and skill, fit for the particular purpose they were supplied, and the service must be completed within a reasonable time and a reasonable price, if no price or pricing formula had been previously agreed. What rights do consumers have when they aren't happy with their good or service? The rule is that if it can be fixed, fix it. If not, the consumer has the option to replace it or be refunded. A consumer can ask for a replacement or a refund if the good or service is not remedied within reasonable time, when the good or service can't be fixed, or if it is a failure of substantial character. A failure of substantial character is when a product or service would not have been acquired had the consumer known of the nature or extent of the failure, or when it doesn't match the description in significant ways, or if it is unfit for a purpose commonly supplied, or unfit for a purpose made known to a supplier, and can't be fixed, or if it is unsafe. Now, at times a fault in a product or service is going to cause damages, which can result in a loss financially. This is called consequential loss. Regardless of how minor the fault is, as long as any damage done from the faulty product is reasonably foreseeable, a consumer can claim damages. One thing to note is that when claiming for consequential loss, this must be done as soon as the issue is known. If it is delayed, the remedy may be lost. The CGA can only be contracted out of when it is a business-to-business transaction. When a business buys a product ordinarily used for domestic use, but uses it for business purposes, under certain conditions the CGA can be contracted out of. These are that any contracting out must be done in writing at the point of sale, both parties must be in trade, and the terms must be fair and reasonable. What does this mean for small and medium-sized enterprises? It must be stated that it is of utmost importance to comply with the CGA to avoid fines and trouble with the law. Ideally, by following the main parts of the Act, which are to be honest about your good or service, making sure your product or service is of acceptable quality, you should never have to remedy. In the odd chance a fault does occur, have remedies available, which will satisfy the customer.